I'm Brooks Felsman. I'm the staff attorney with the Community Law Program. Specifically, I assist with landlord-tenant eviction defense matters. This presentation is to help inform tenants of what their rights are, how to best go about advocating for those rights, and just general practices to help you get the most out of your lease and avoid potentially having a landlord trample upon your rights. Aidan Brown is going to be helping with the slides. We will go over a couple pertinent topics that come up frequently in landlord-tenant cases, and then we'll briefly answer any questions that people may have here. Aidan, you want to get the slides going?
What is your name again? I'm sorry, correct?
Yeah, no problem. My name is Brooks Felsman. So first, just briefly, some statistics regarding evictions in the greater Tampa Bay area. Again, there's just over 350,000 renter households in Pinellas and Hillsborough counties. The average rent in between those two counties is around $1,300 per month. Of course, this has noticeably gone up post-COVID. Eviction is, of course, present in our communities, but it's extremely much more common in certain areas within Pinellas County and Hillsborough County, particularly in Pinellas County, in the southern part of the greater Pinellas Point area of Pinellas County. And eviction rates are consistently higher post-COVID than pre-COVID. And importantly, what I hope everyone can get out of this, whether it be effectively defending against an eviction suit or reaching a settlement, is that our main goal in any eviction defense matter is to avoid a final judgment. So final judgment then essentially means that judgment means the judge has ruled. And in this case, they've ruled that you have been evicted. That has some very serious repercussions for any potential tenant. Notably, bad credit can make it more difficult to take a small loan, finance payment for a car, buy a home, getting another place to rent potentially. So we're always hoping to help people avoid a final judgment in an eviction matter. Go to the next one. This map up here shows where eviction rates are highest. The red indicates a higher eviction rate. And I believe these circles, the larger the circle, the greater the number of eviction rates. So down there at the bottom of Pinellas County, you can see there's about 3 or 4 much larger circles. That's the greater Pinellas Point neighborhood. There's several large apartment complexes down there where evictions are quite a bit more common. And then a little bit in the north area, just west of where the Franklin comes in, is another real hot spot. Thankfully, the city of St. Petersburg has some programs to help with eviction defense matters. And that is typically where we see the most action. In some senses too, you should be aware that a lot of these communities retain the same attorney, so they are somewhat habitual, somewhat business-like in the way they go about filing evictions. They're very experienced, they know what they're doing. So a lot of these bigger communities are not novices at filing, versus if you're going, a landlord or the owner themselves can of course file an eviction suit. They tend to not be quite as effective at streamlining and speeding up the eviction process as when the communities, like the large apartment complexes, hire an attorney specifically because they will file motions for final judgment or writ of possession much more quickly than if you're going up against an owner who's representing himself. The next one. So again, your rights are really only as good as what you are aware of your rights are, and then second, how to go about advocating the rights. So again, a big part of this is to help make you aware of what your rights are and how to advocate for those rights. We're going to cover a couple areas today that frequently come up. Some of these issues can really be spearheaded before the lawsuit's ever filed, and quite frankly, that's when you have the most negotiating power in this. There's a real power imbalance dynamic between landlords and tenants. Landlords have more money. They can wait you out, but also once they file the suit, things go quickly. In Florida law, evictions are governed by summary procedure. Summary meaning shorter, it's quicker. There's not an evidentiary period. These things typically, if everything is filed in the right way on time, can wrap up in just under 15 days. That's extremely fast compared to average civil litigation. The average is about 18 months. On the shorter end, 12 months. On the longer end, closer to 24 months. So we'll cover leases, important terms in the leases, and some practices for saving your leases because it can avoid real problems later. Notices, the different types of notices and the things to be on the lookout for in those notices. Security deposit issues are a common issue. What is a security deposit? How do you get it back? How is your security deposit taken away? What are the situations where you essentially forfeit the security deposit? The issue of repairs. Repairs can become an issue with any lease. Repairs can sometimes result in having your rent reduced. Repairs can also offer a partial defense during an eviction matter. They might lower your rent. And then last, we'll briefly touch on the eviction process, what comes up during the eviction. And then last, we'll answer any questions that you here have. Excellent. Okay, so while leases can range anywhere between maybe 8 pages to 16 pages, they do have almost always several traits in common, sections in common. And the important sections to really pay attention to: when is the rent due? Some leases say it's due by no later than the 3rd day, the 5th day. Some are very strict on the 1st day, so be aware of when the payment is due. Next is how to get out of the lease. There's certain things you need to be aware of. There might be a notification period. You might need to give a certain number of days. You might need to send the notice to a certain mailing address. It might need to be in writing versus instead of just a telephone call. Where do you send the notice to? Not just for potentially terminating a lease, but also letting your landlord know that something is broken with the property. Landlords, at the end of the day, the property is their investment. Most landlords want to know if something's wrong because they want to keep the property in good condition. Maintenance responsibilities. If you have them, what are they? And also too, being aware of what are the maintenance responsibilities of the landlord. It can depend on the type of building you're in. It can also be defined partially by the lease. And then last, community rules. Community rules, especially, are more common in apartment complexes than, say, if you're renting a home or a duplex. But community rules are important because they frequently come up in notices of non-compliance, where you may get a 7-day notice to cure the rule violation, and then there's situations where the notice to cure the rule violation, they don't have to give you an opportunity anymore, but we'll go into greater detail on that as well. All right, thanks. All right, so this is an example of a very common lease form prepared by the National Association of Apartments. It's very standard language in here. So in this one, they're saying that the rent is due by the 4th day. In theory, if you get to, let's say, July 5th, you have not paid rent, that is the earliest where they can post the 3-day notice to either please pay the rent or deliver possession of the property, aka move out and take all of your property out of the property. They also, this one, and this is common, include a late fee. There is also a charge typically for if you give a bounce check. They might call it an NSF check, meaning not sufficient funds. To bounce check, you don't have the money in your account for it. Importantly, and this is a good example, this is a pretty well-written contract, the last sentence here states, all payment obligations under this lease contract shall constitute rent under the lease. Legalistically, this is a very important point. When you have failed to pay your rent, it's only, the 3-day notice is only supposed to allege the rent that you owe. So, if they don't have a sentence like this where they say that the payment obligations constitute rent, without that sentence, they can't claim the late fee. But when they include that sentence in there, now that 3-day notice can include the demand for the late fee. So that's something to be aware of. Technically speaking, under the Florida law, 3-day notices for a failure to pay can't claim anything that isn't rent. And if they do claim something that's not rent, it may in fact be a defective notice, which could force the landlord to restart the process of giving you 3 days to pay, filing the complaint, attaching the complaint. They serve the complaint on you, you get 5 days. We'll go into more, there's some technicalities there. We can move to the next one though.
Oh, is it possible, excuse me,
Yeah.
I'm sorry.
Yeah,
Is it possible that, does that, like the 4th day, the 3rd day that you're owed, does that go like a business clock? I mean, you know, like 11:59 p.m. or the end of the business day?
That's a good question. So it kind of breaks down 2 different ones. So in this one, no, if the 4th day falls on like July 4th, for example, a legal holiday, or if the 4th falls on a Saturday, the payment is still due by that date. Where there's an exception for weekends or holidays relates to the 3-day notices, those can't fall on a weekend or holiday. And similarly for if you are a defendant in an eviction lawsuit, you receive a summons with the complaint, you have 5 days, business days to respond typically. If that 5th day were to fall on a holiday or a weekend, it goes to the next day. That's not a weekend nor a holiday. Anything else on this one for
Well, right, in terms of a timestamp, the moment that you submit your lease or your rent, if they don't mark it until after the, just to see if they can get you to pay extra for a late fee.
Mm-hmm.
That's obviously not legal, but how do you, there's no timestamps.
Right.
When you slide your rent.
Yeah, so that's a good question. So we will get to that as well, but what we were going to recommend here, I'm glad that you brought it now though, is pretty much anytime you make a payment, you should take a photograph of it. Try to have something to reference it. We see sometimes where the landlord isn't necessarily trying to get one over, the tenant's not trying to be sloppy, but bad records can lead to lease disputes where the person did pay it, but maybe the landlord for some reason forgot to cash the check. They're just looking in their ledger and they didn't see that. So sometimes these problems can be preempted if you simply just take a photograph and document, keep a receipt, some way to show. If you are paying with a cashier's check or a money order, that comes up a lot too. When you pay it out, it's going to list who it's paying to, but then there's going to be a little stub at the bottom. It might not show who it's being paid to. So before you rip it off and you perhaps keep the receipt, take a picture of the whole money order and cashier's check. That way you have definitive proof that I offered payment, it was for the right amount to the right person, and you can perhaps avoid it. So that would be my recommendation on that. And because legally speaking, when you've offered the payment, they call it like the mailbox rule. So you've offered the payment, maybe they haven't received it yet, but you set it out, let's say you were in this case, rent was due by the 4th, you had to pay by the 4th. On the 5th, they gave you the notice. You go to try and pay on the 7th day of the month, and you're concerned about this issue, take the picture, document it, but as long as you have that proof in there, you're gonna be able to show that you essentially offered the payment on time, even if they maybe didn't pick up the check until the 8th and they didn't cash it until the 9th. So you should be insulated from risk there. Does that answer your question?
Yes.
Cool.
Yes.
Go to the next one. Okay, so quite a bit we get asked by tenants about getting out of the lease. Maybe they're moving somewhere for a new job, they don't like their neighbors, they think their landlord is harassing them, they think it's a bad deal, they want to get out. There are different rules governing the different types of leases. Some people are in leases and it's a verbal lease, there's no written contract. There's a different statute for terminating that kind of lease than terminating a written down lease like we saw on the different slide. So we do see quite a bit of times where people have verbal leases and a lot of times the landlord may want to terminate the tenancy. There are certain timing requirements for how much notice, how much heads up you need to get. So in this one, it's without a specific term because it's not written down. If you have an oral lease, we don't know exactly when it stops and starts. It just depends on, it ends when they stop wanting to pay each other. So you have to give the other party written notice. And the amount of notice that's required is going to depend on the payment interval. So if you're paying once a year, you gotta give 60 days notice. If you're paying quarterly or monthly, so you pay either every 3 months or you pay at the start of every month, you're entitled to 30 days. And then if you're in really short-term housing, you're paying rent every single week, they only need to give 7 days notice. But if you are in this situation where you have essentially an oral lease, there's no specific term, and let's say you're paying monthly, they need to give you at least 30 days notice. So if on May 7th, and also importantly, it's 30 days prior to the end of the monthly period, and that really matters. It's not just giving them 30 days, it's 30 days prior to the end of the monthly period. I think we might have an example on the next slide. Okay, so here's an example here. The tenant is living in a property on a verbal lease, is paying rent once a month. On June 27, 2024, the tenant receives a 30-day notice of termination of tenancy. The 30-day notice states that the tenant must be out by July 27, 2024. Is this a valid notice? We go to the next one with the answer here. Well, the answer is no. So again, the tenant there is living under a verbal lease. There's no piece of paper defining how long the duration is. So it is a non-specific duration. The relevant statute here is Florida Statute 83.57. Under this type of lease, they must get a 30-day notice before the end of the monthly period. So the June 27th notice is only 3 days before the end of the monthly period. They need 30 days. So it does not satisfy the 30-day requirement. The earliest the landlord can get the tenant out of this type would be a notice of termination of lease that would end in August 31, 2024. The reason being is that if they give the notice on June 27th and they say it's 30 days, now they have a whole month of July essentially to get everything ready to get out. This comes up a lot. A lot of times landlords think they're in the right. I've given you the 30 days, but it's 30 days before the end of the payment period. So you got to get at least a 30-day buffer before the next payment period.
I have a question.
Yeah.
Does it matter what, is that assuming that your rent's due on the first day of the month? What if your rent is due on the 15th day?
It's going to be based off of when the payment is due. So
rent's
if it was
first.
due May 15th, then everything's going to be shifted. Then it's got to be at least 30 days before the next 15th of the month payment. So yeah, it's not driven by the date of the month, it's driven by when the payment is due.
So in that example, it was due the first day of the month.
So yeah, it'd only be shifted back 15 days. If it was, rent was due on, I guess it'd be the 15th, so July 15th, August 15th, then to get them out, in that case by July 15th, they would have to give the notice by essentially like June 14th or something like that, where that way there's at least 30 days of a buffer. When they do it here at the end, now there's only 3 days for the next period. So that's what's driving it. It's not the amount of days given, it's the days before the next payment that's driving it.
And that grace period, basically, like you said, when rent is due on a particular day, that's, if it's due on the first, but they give you a grace period up to the third, I mean, but it's still due on the first.
And there's a little bit of room to argue too with these oral leases because again, nothing's written down, nothing's defined. So there might be the conduct, they could say, how you guys are paying. Do you pay between the first and the third and they never give you any problems about it? Then the court might deem that yeah, payment is due no later than the third because there might be a little bit of variance of when you're paying it. So there's a little bit more wiggle room to argue when there's a non-specific, it's a verbal lease. A lot of things are not specific in reality. Your lease is governed pretty much exclusively by statutes because nothing's defined. Okay, this of course contrasts with a lease with a specific duration. So this is essentially going to be almost any written lease. I can't imagine a written lease where they don't say it starts on this date, it ends on this date. The notice period is quite a bit different here, but the big part here is the highlighted section. So there is a requirement when you're giving the notice, and so really they can require, the notice period can vary a little bit, and the parties you can in theory negotiate it. You might not have a lot of negotiating power with the landlord, but you can ask. But essentially, the landlord and yourself cannot be obligated to give more than 60 days notice. So they can't say, if you're going to move out, you must give us 90 days notice. That would be an invalid clause. The court would probably just reduce it down to 60. They can't say either party can terminate the lease with just 20 days notice. It has to be at least 30 days. But the courts will give the parties who are writing the contract a little bit of discretion, a little bit of input about how much notice they want to give. All right, so this one, a tenant signs a lease starting on January 1st of the year and ends December 31st of the year. The lease specifies that either party must give 75 days notice to the other if they wish to terminate the lease early. Is this an enforceable notice privilege? As we talked about, the answer should be no, we'll see on the next slide. So no, reason why here is they're not requiring more than 60 days. It has to fall in that 30 to 60 day range in terms of amount of notice needed. All right, so leases are, at the end of the day, they are everything for your tenancy rights. They're not just the brain, they're not just heart, they're the brain, the body, the blood. They are everything. So keep this document, your signed lease, but even the unsigned one, as long as it's the same, is fine. Keep it in a safe place. If you got a personal safe, I mean, these can range. You can get a cheap one closer to $30. You get a little bit nice, but get one that has maybe some water, some fire durability, because this is going to define your rights. You don't want fire sprinklers to go off, and now you've ruined your best reference point. Now, granted, your landlord should always give you a copy release if you ask for it. There's no reason why they can't give it to you, but they might be slow giving it to you. So if you don't have a copy, ask your landlord for a copy. They need to give it to you. But by all means, a lot of problems can be solved by holding on to your lease, because as we'll talk about later, some responsibilities can be the landlord's or the tenant's in terms of maintaining the property, but the lease is going to tell you whose responsibility it is. Go to the next one. Okay, so again, you want to keep the lease for a couple of reasons, but the big ones are: when is your payment due? How much is due? Is there a late fee? Does it say that we're considering late fees as an additional cost of rent or as a part of the rent? So this here is from the Florida Bar. Actually offers eviction forms for any property owner to use. This is just a standard form for a failure to pay rent, aka a 3-day notice for failure to pay, so either pay or deliver possession. So in here it's got the typical language: you're indebted to me a certain amount, or the address of the property, and then it goes, I demand payment or possession, aka you moved out, you removed all your property, you've given them the key from the day of delivery to notice. Now we're going to go into a little bit of detail. There are certain technicalities that may give you more than 3 days, and they tend to do with the landlord's address up there. At the bottom of this page, there's a little section, and it'll be the contact information for the landlord. Say their name, their address, and they got to put a phone number, because they want payments, so you need to be able to get a hold of them. If they don't put that contact information in there, how are we supposed to get the payment where it needs to go? That too might buy you some more time. So we'll go to next. So there's several things that I look for anytime I'm trying to help out some of the eviction defense. So first, does the 3-day notice expire on a Saturday, a Sunday, or a legal holiday? So next week's actually a pretty good example. 4th of July is coming up, so any sort of 3-day notice that was maybe given at the end of June, if that 3-day notice ends on the 4th of July, it's not going to work. It needs to go to at least the 5th, because that's a legal holiday. If it ends on a Saturday, Sunday, that's not going to work. It ends on a weekend there. So does the notice not contain an expiration date? And if you think about it, that makes sense, because really the 3-day notice is, in some ways, it's an ultimatum. Pay, give me property, or else I'm going to sue you. So if it doesn't have an expiration date to really, in fact, make an ultimatum, it's also defective. Does the notice indicate the method of service? Means how did they get it to your property? Did they mail it? Did they tape it, nail it to your door? So the method of service is not indicated. It may be impossible to determine whether sufficient time has been given. We'll go into a little bit more detail about that. But the big thing here is that if they mail it, you're probably going to get a little bit more time to respond. Okay, so was the 3-day notice mailed or was it posted? So the Florida rules of just general practice essentially give, and not just in the landlord tenant, but if things are mailed and they want a response by mail, you're going to get 5 days to respond by mail. It just accounts for the fact that the USPS is not known for their speed. You're facing eviction. You're not like flush with cash to use FedEx and USPS. You're sending it by the mail, so they're going to give you 5 days there. But also too, you can get a little bit more time where, again, the landlord, the demanding payment, has to explain where to send the payment. And what matters here is, you know where you live, what county you're in. Does it ask you to respond to an address that's outside your county that you live in, or does it ask you to send it to a PO box? If it does either of those, you're going to get 2 extra days for that. Because there's this understanding that the PO box is not in the landlord's property. They got to go, leave their house, come to the post office box. Sometimes you can't get to the PO box past a certain hour. Kind of depends on the station. Also, too, there's understanding that if you live in Pinellas County and your landlord lives up in Pensacola and Escambia, it's going to take a little bit more time, so they'll give you a little bit more time. So in theory, you can raise these arguments in terms of when is your payment actually due. All right. Like I was kind of alluding to in the earlier slide where we talked about the amount of rent goes due by the 4th day, and then at that last sentence that the late fees are being considered an additional rent, that matters in the 3-day notice. So again, this is straight from the Florida statute that literally defines what rent is. But rent is periodic payments from the due to the landlord from the tenant for living in the property, and any other payments designated as rent. So again, that's why the late fee in the other one counted, was they had a specific sentence that designated it as rent. Without that sentence, they're probably not getting the late fee. I would at least challenge that to say that it's not a sufficient notice. Also too, it must be the precise amount of rent due. If the number is wrong, for example, rent is $1,000 a month. They say that you haven't paid rent for that month where $1,000 is due, but you know that you paid, you kept records preferably, that you paid at least half of it and they accepted it. Well, now you know, like, okay, fine, I didn't pay all the rent, but this is the wrong amount. I paid half of it. I really owe $500. You're demanding $1,000. This notice is defective. You can get them to reissue it and put the correct amount, and that is a requirement. This is a Supreme Court case, Baker versus Clifford, and it's also in the Florida statute. It's got to demand the precise amount of rent or something designated as rent in the notice. So now this is another somewhat common type of notice that can potentially lead to an eviction, although these are easier to deal with. So this is a notice of non-compliance. So again, especially if you live in an apartment community or maybe somewhere that has like 8 or more units, there's probably gonna be community rules. You gotta be quiet by these hours, you can't leave trash in the hallway, you can't have X number of guests over, if someone stays a certain number of days, they're no longer guests, you need to add them to the lease, whatever it may be, but there are community rules. Now, there's different types of ways you could not be in compliance with the lease, and essentially they get grouped into 2 categories. Problems with the lease that you have a chance to cure, to correct, and problems that we're not giving you a chance to cure or correct. So most, again, fall into you get an opportunity to correct it within 7 days. And also, importantly, and anytime you get one of these 7-day notices, but I do see some really vague ones, is that they have to be specific. You really gotta know, what are you actually complaining to about? What is the rule I violated? What did I do on what date involving what people? Kind of the who, what, where, when, why. They can't just be, tenant is disruptive. How am I disruptive? Am I disruptive after hours? Am I like doing donuts in the parking lot? Am I banging on people's doors? It's gotta be specific, because otherwise, how are you supposed to respond and show that I'm not violating the rule anymore unless they're specific enough? We can go to the next one. So, this is just a general practice point for anyone who's gotten one of these, but let's say you're in a situation where I've seen this apartment complexes where they have maybe a couple of dumpsters on site, possibly a large trash compactor, and they'll say, tenants shall not leave garbage outside their units in a bag. You gotta put it in the dumpsters or the trash compactor. And they say, you know, Mr. Jones, you've been leaving trash outside your apartment. You need to put it in the designated places. Remove the trash, put it there, take a new photo, you know, because you can also usually show the date on it, send it to the landlord too, because sometimes you've cured the defect that they're asking you, but the landlord might be at multiple properties, they might be out of town, and they might just not know, quite frankly, that you have corrected it. So take the time to, 1, correct it of course, but 2, document it and send it, sort of remove the excuse that, oh, I didn't know that you've cured it. Let them know. Again, that's why it's important to keep your lease, because it's going to tell you where to send the notices. So because you might maybe send the notice to the wrong person. You send it to some, you know, assistant property manager that doesn't deal with the notices. You need to send it to the right email address, whatever it may be, call the right number, let them know. Okay, so the real thing to be aware of is, again, I'll get more into the types of non-compliance that you don't get a chance to cure. But the more common one is, you did some minor rule violation. You left the trash out in there, that's not a big deal, you pick it up, you put it in the right place. The issue becomes is you get a notice within 12 months for the same violation. Now the landlord does not have to give you an opportunity to cure, even though it's potentially a really minor thing. Like, you parked in the wrong spot, but they warned you once, now they've warned you twice, they don't have to give you a second chance anymore. This is not baseball, it's not 3 strikes you're out. it's 2 strikes and you're out. So, and again, the other important part here is the 12-month period. So right now it's June of 2024. If I was notified in May of 2023 that I left garbage bags outside, that's a violation of the rule. Now 13 months later, I've left garbage outside, I'm okay. I get another chance to cure it because those are more than 12 months apart. But if it's June 2024 and in January 2024, I violated the same rule, well, those 2 violations are this, number 1, they're the same violation. Number 2, they fall within a 12-month period. Now I'm not entitled to an opportunity to cure. They can just give you basically a notice to vacate and just be like, you gotta get out in 7 days. And that's pretty much that. Now, actually go back briefly. And then last is the types of violations where they don't have to give you 7 days. It's not specifically defined in the Florida statutes. The case law, which is just previous cases that judges have ruled on, kind of give us a sense of the types of actions, activities that they just don't have to tolerate. The big ones are you're destroying the landlord's property, you're destroying other tenants' property, maybe you're smashing the walls, the doors, you're breaking down someone's car, or maybe sort of extreme violence, like you're beating someone up, essentially it's just completely intolerable. It tends to be like, it's bordering on a violent crime or a property damage crime. That's generally where it's at, but it's not specifically defined. There's a little bit of discretion that the court will use here in terms of whether or not you give them a chance. I don't think smoking in in an apartment unit or any unit would probably fall into that category because is it damaging the property? Yes, but it's probably not the same as punching a hole in the wall. Because it's pretty easy to cure. Like you could just smoke outside. You could smoke on the porch. But you do that same violation in a 12-month period, now you got a different situation. All right,
I have a question. So, have you seen instances where perhaps the landlord or different landlords are on record perhaps for making egregious kinds of allegations of their tenants and that kind of thing? So there's a reputation that they may have and it may have favor when you come to court with their story.
So the question here is, have I seen situations where a certain landlord is like very kind of like whining or that they complain a lot? Does it give you more credibility with the court?
Basically,
Maybe. I think probably in that situation, it probably sounds like, I think such a, I don't want to say litigious, I don't know necessarily always going to a lawsuit, but the landlord who's complaining a lot, that's probably the landlord who's probably being a little bit too vague in their allegations. I think if you're being specific enough, you're probably going to send a slightly less held one, but it would be hard to necessarily show because I don't know if you maybe would have access to enough of other violations. I mean, maybe if you had it and you could show the court that like this landlord files a lot of frivolous notices. I just don't know if you could raise it. I think there's some practical limitations on the average tenant's access to other people's complaints. Now, maybe if the tenants are really well connected and they are kind of holding out the notices and they can pull it together, then maybe they could show it. But really, you'd be responsible for responding to your specific complaint. So just because someone has been a sort of boy cries wolf in the past doesn't necessarily mean that there isn't a wolf here today, sort of deal. But maybe if you got into the hearing stage or something and you're talking about retaliatory eviction, that's another can of worms there, then maybe that would probably lead into, lending credibility that this notice was done out of retaliation. It might be more effective there. Did I answer your question? All right. So we've got 2 examples. One example here. The first is just a brief explanation of the facts. So George is renting an apartment under a written lease. He has lived there for 2 years. The apartment also has community rules. One of the community rules is that tenants shall not leave trash outside their units and instead must place their trash into the community's trash compactor or other dumpsters on the property. The first situation is in March of 2024, George received a notice that he left trash outside his apartment in violation of community rules. It's the first time he has violated this rule in the last 12 months. is George entitled to a 7-day period to correct the violation? You want to take a guess here?
Yeah, I say, yeah, I guess, well, I mean, yeah.
Yeah, there you go. You're 1 for 1. Good stuff. So again, because it's the first time he's committed a violation in the last 12 months, he's entitled to an opportunity to cure. Also, too, importantly, this wasn't he's not destroying other people's property. He's not destroying the landlord's property. He's not engaging in some sort of probably like violent behavior that's like a real threat to people around him. So he's going to get a chance to cure it. Let's see the next one. So now, again, same facts. It's March of 2024. George received a notice that he left trash outside the apartment again. George also violated this rule in December 2023. Is George entitled to a 7-day period to correct this violation?
No.
All right, I think I heard a no there. So yeah, that's correct. No, because again, this is the second violation of the same rule in the 12-month period. Now, again, he could have left the garbage out there. That could have been his first violation, and he could have parked in the wrong parking spot. That's a second violation. But they're not the same violation. In that case, he got the chance to cure. The issue is same violation, 2 violations of the same rule in a 12-month period. They don't have to give him a chance to cure. Now, maybe you could reach out to the landlord and send him a letter, apologize, I feel bad, blah, blah, blah. There's always the chance that like a nice letter could potentially smooth it over. You can always try, it doesn't hurt. What was that?
They're not legally obligated.
But they're not legally obligated.
Is there a limit on like how many minor different notices that they, like?
No, I mean, if you keep violating the rules and they keep responding to every rule violation, that is within their rights to go about enforcing the community rules. And honestly, if I was on the other side, I might advise the landlord to be diligent about reporting rule violations, because the landlord can potentially come across issues of arbitrary, aka random rule enforcement. When George leaves his trash out, he gets notices, but when Sally leaves her trash out, she isn't getting any notices. And this inconsistency could open up that landlord up to, like legal problems in terms of you're being arbitrary and capricious. You're being kind of spiteful, as capricious there, with your rule enforcements there. So, no, there is no limit on how many rules. If you keep breaking the rules, you're gonna have problems. So don't break them, but also too, you break them, cure them. If you cure them, document them, let them know.
And only break different rules after that.
Yeah, that's a big thing. And don't destroy other people's property and don't be violent. Okay, so we've got a 3-day notice here. So you receive a calendar of July 24th. You receive a 3-day notice on Wednesday, July 10th. When do you have to respond to your 3-day notice, which is again either pay the rent or give possession? So when does the 3-day notice period end? And again, it starts on July 10th. Anyone want to take a guess here?
The 15th.
Correct, yeah. In this case, it's going to be on the 15th. So you got it on the 10th. You don't count the day you got it. We start the next full day. So the first day is 11th. The next day is the 12th. But then we can't count the 13th, it's a weekend. Nor can we count Sunday the 14th, it's a weekend. You have until essentially 11:59 p.m. on Monday the 15th to either move and get all your stuff out, let them know, or pay the amount in full. Otherwise, they might kick it up into a lawsuit, because giving the 3-day notice and letting the period pass is a legal requirement for filing a lawsuit. If they don't do either of those, they don't give the 3-day notice, or they don't give you enough time, in theory, that is a defective notice, defective lawsuit. They got to start the notice period again. Okay, so I do see a lot of questions with security deposits. Everyone hates paying security deposits, but they exist for a reason. The big one is to make sure that the property's not damaged, and then the leases might define it. It could also go towards ensuring that your performance, aka paying rent when it's due, and paying it in full. So there are rules though for how the landlord has to claim it. It has to do with how quickly they give you the notice, and essentially how they send the notice to you, and then also to what their reason is for claiming it. If they fail really any of those conditions, you're entitled to get it back. So when you vacate, and the landlord does intend to claim it, they have to return it within 15 days. If they do want to claim it, they essentially have 30 days, and they have to send out, importantly, certified mail. So that's the type of mail where you sign for it. The post guy comes up like, hey, I need your signature. That's certified mail. It's different from regular mail. To the last known mailing address. So anytime you're moving out, you're getting evicted, you're planning on moving out, you need to give the landlord the address of where you're moving to, because you might kind of shoot yourself in the foot here. You might have not damaged the property. You paid everything on time, you moved out on time, but you never let the landlord know where to send the updated, where you're moving to. Technically, they haven't really violated the statute here because you never gave them your new forwarding address, your new mailing address. So really important to give them that. So they got it within 30 days, certified mail to the address you gave them, and their intention to claim it with a specific reason. And it cannot be something like, the legal term is wear and tear, which so if you live in a house for 10 years, a couple of years, 2-3 years, there's gonna be an expectation. There's gonna be a little bit of scuffing on the walls, moving furniture around, maybe the carpet's gotten a little bit matted down, just normal, you've been living in the place. They can't claim for that. It's more, the window is broken. There's a hole in the wall. Something like that. The plumbing was fine before and now it's not. Now that's a specific reason, and it's not just the regular things you would expect, just living in the same living space for a period of years, or even just 1 year.
Oh, can I? Oh,
Yeah,
okay.
yeah.
Can I ask you about, when did the interest thing, like, if you've been there for 10 years, didn't they used to give you a little interest?
Yes, so there are different ways that a landlord can store the money. There's, I think, 3 different ways. They can put it in an interest-bearing account, they can put it in a non-interest-bearing account, they can potentially separate your deposit from others, they can commingle it with other security deposits. I believe, and I'd have to double check, I think though if they put it in interest-bearing, they might have to pay you a certain amount. It really doesn't come up very often. Most landlords, for that reason, just to keep things simpler, yeah, and avoid people raising questions, they typically don't put it in interest-bearing accounts, but yeah, you may be entitled to interest. Then again, it might not be an incredibly large amount of interest if you're only there for 1 year.
Right.
But in theory, but double check, again, that will almost always be specifically defined in the lease. Usually within the first page or 2, they're gonna talk about the security deposit. How much it is, what it's for, the type of account it's held in. So we can go to the next one. Okay, actually, go back for a second. I want to say one last thing here about security deposit. So in general, the Florida statute says security deposit is for ensuring performance, and that's sort of intentionally vague. Again, the main performance in a lease is you provide housing, I provide money on the date that it's due. But the lease, especially not in an oral lease, but in a written lease, can kind of add and further explain what they mean by performance. So it might be that, like, not just that you're gonna stay there the full time, but the property's not gonna be damaged, that you're gonna give them the right amount of notice. So they might give a little bit further detail about what they mean by specific performance. So typically too, if you get evicted or you move out early, you're probably not going to get the security deposit, because a lot of times there'll be language in there that the security deposit is there to ensure the full performance of all obligations, and that in a lease, they're really talking out there. All obligations includes that you stay for the entire duration and you paid the rent for each rental period. So if you move out 9 months into a 12-month lease and it has language like that, the security deposit, in that case, well, you moved out early. So you didn't perform all the obligations, they might use it to get some of the rent for the 3 months that you moved out early for. They might also throw language in there like liquidated damages. This is a legal term for saying that we both agree that I lost money financially, I've been financially harmed. But we also agree that it's sort of hard for me to define how much I've been harmed financially. So we're going to define essentially a penalty for how much harm it is, because instead of the landlord receiving the next rent check, now they are spending money, maybe putting out advertisement, interviewing people, reviewing applications for it. So they're not only not receiving the money, but they're also expending a little bit of money. So they'll typically include language saying that if you move out early, we're gonna consider the security deposit as liquidated damages to make up for the sort of financial harm that's come by you leaving earlier than you previously promised us. It might not include that language, and if it doesn't include the language, then really it's just gonna go towards damage to the property. But for that reason, most leases do try to sort of elaborate on what they mean by performance. Okay, so first two, this is a part of Florida Statute 83.51. There's a paragraph, it's 8351B. The paragraph 4.1a also talks about how landlords are required, property owners too for that matter, are required to comply with applicable building and housing codes. So we are in St. Petersburg, Florida right now. St. Petersburg has its own code of ordinances. It has a little bit of heightened requirements for the condition that the property needs to be in. So landlords have to comply with that, but also too, if there are no applicable building codes, maybe you're in an unincorporated part of Pinellas County and you're not somewhere that's a municipality, there might not be a city building code. So there's other just guarantee, you could be in really rural area for it, guarantee things that all landlords must do. So maintain the roofs, windows, doors, floors, steps, porches, exterior walls, the foundation of the property, other just structural components. So you think of building, you think of four walls, a foundation, a roof, the windows and the doors. That's really what they're getting at there. And the plumbing should be in a reasonable working condition. And I do believe they almost always include the electrical sort of wiring too in a house. And again, these need to be in good condition. So if for some reason there's, I've seen homes where you have your roof, there's an area that it goes kind of, it's curving into the house. That area is called the soffit. It's kind of the flat part where you look straight up. If that soffit is hanging there, you might have a case that the component of the roof is not in good condition. You can legally require the landlord to fix it. Because if you kind of think about it, there is again, power imbalance. Landlords have more money. They are in a better position, also they own the property, to repair these really big expenses. Whereas the tenant might be responsible for really more minor things, replacing a light bulb, things like that.
But there's no appliances here, right?
No, there is not. These are again just the big picture requirements for any landlord. So like the really big ticket things. So like this floor maybe is a little bit scuffed up. Landlords probably wouldn't be required for that, but there's a massive hole in this exterior wall. Like this is no longer habitable. We're not being protected from the elements outside. That's really kind of the standard. So we think about it like you need food and shelter. If what you're renting isn't giving you shelter in a sense, wind is coming in, rodents are coming in, like bugs are coming in, then you can require them. Also too, I think it could be in the paragraph before, but once a year, landlords are required to maintain the screens in the property, which is an acknowledgement. There's a lot of bugs and insects in Florida, so your screens actually once a year need to be repaired. It's not super expensive. It's a little maybe tedious for the landlords. They might not want to do it, but once a year they are required to repair your screens. Okay, now there is also an acknowledgement there's just a different reality between living in a single family home, a duplex, maybe a large apartment building, or a condominium. And certain building maintenance things cannot be discarded in terms. So one of the really big ones we see is with apartment complexes is that there might be an issue with rats, mice, rodents, termites, things like that. And if you live in those larger communities, it's completely invalid if the lease says you live in an apartment complex, the tenant must once a year pay for a termite inspection or roach inspection, or for the tenants must pay for removing vermin like rats and mice and things like that. There's just an acknowledgement that apartment complexes too, that we're not going to obligate 1,000 tenants to each hire someone from Terminex or whomever to go out there and do an inspection. In those types of communities, the landlord is always on the hook. They can't discharge that duty. But that's different than a single family home or a duplex. So a home is vertical, horizontal, duplex, doesn't matter. In that one, the landlord can put in the lease that it's now the tenant's responsibility. So, for example, I live in a duplex. My landlord could, in theory, be like, Brooks, you need to do a inspection for mice and rats and termites and all that stuff once a year. They can lawfully make that my responsibility. if the lease doesn't make my responsibility, the default is the landlord's responsibility. But single family home, duplex, they could make it your responsibility as a tenant. Apartment building, basically not single family home, not duplex, that's always gonna be on the landlord. We got next one, Ian.
Question?
Yeah, sure,
Just a scenario.
sure.
The apartment is a building, 8 units, air conditioner comes with the apartment.
Okay,
The air conditioner was known to break down and when somebody over.
yeah,
The tenant travels a lot for work, and they come back and their condition is broken.
Mhm.
To the extent that mold is now on all of the furniture, like the sofa and the table and linens.
right.
Who's the onus to mitigate that issue?
So, that's a good question, and definitely comes up a lot during this time of year in Florida. Glad you asked it. So, it almost kind of falls into two categories. Oddly enough, Florida requires landlords to provide heating, but not air conditioning. Doesn't seem to make sense. But really quick, so really two things here. So, fixing the air conditioning may technically fall on the tenant there. I do a lot of times see they'll put a specific provision for maintenance in there, and they'll list a bunch of things. Floors, doors, plumbing, electrical fixtures, on and on. They'll say landlord, tenant, and they'll put like a check or an X. That would be the first place I would look. Because I have seen some where it obligates the landlord to do it. So that's why it's also important to keep your lease. Landlords hate fixing air conditionings. They're kind of expensive. They have a lot of different parts. You got compressors, you got your coils. Check there first. Because if not, you could, technically, if they just don't define it, it probably is going to be the tenant's responsibility. But the mold part, though, kind of falls into these other categories of the building code. A lot of times, I know St. Petersburg is one of them, they can't rent out a property that has too much mold, basically. So you could probably obligate, in that scenario, again, the lease would really define the rights. You may be able to obligate the landlord for remediating the mold, but you may be on the hook for repairing the air conditioning. But again, if you keep your lease, hey, maybe the landlord's responsible for fixing the air conditioning, and there's probably a better chance than not that the landlord is definitely going to be on the hook for fixing the mold, because there's an acknowledgement. Treating mold is pretty expensive. Mold is also a little bit tricky. Mold is not the same as mildew, and a lot of things look like mold, and they're not mold, and it's really just dirt that's hardened with water. Kind of like you fill a water bottle a lot, it dries out, it hardens, you get a little bit of dirt in there. Kind of looks like mold, but mold is always tricky, and spraying mold with bleach won't get it done. So there's an acknowledgement that mold is expensive to remove entirely, because it might just not be on the surface. Especially, we think of mold a lot of time in air conditioning vents. It might be like deep in those vents. So those treatments will cost a couple $1,000s. So typically that's going to be in the relevant building codes or municipal codes or housing codes for the city or the county or the state. And that should, in most scenarios, be the landlord's responsibility. Maybe in a single family home, there might be some leeway, because maybe the building code says that, based upon the agreement, the tenant may have to do it, but again, you would have to kind of look at the codes. But I would say that one probably, mold is going to be most likely on the landlord. In most leases, the air conditioning is going to be on the tenant, unless the lease says that is the landlord's responsibility. Any other questions?
Oh, in terms of even Venetian blinds, are tenants entitled to Venetian blinds, or is that the owners, the owners of the landlord or the tenant's responsibility? When Venetian blind breaks and things like that, I've seen where, no, you have to buy that yourself.
Yeah, that probably, again, check the lease, because I have seen blinds be specifically defined as a repair item. That'd be the first place I would look. That's a little bit more minor though, because again, let's be honest, a Venetian blind is not a structural component of the building like the roof, the foundation, the walls, the windows. So there's a better chance that could fall on the tenant. I would tend to say that leans probably more tenant's responsibilities, but again, the lease might say to the contrary. I've seen some leases where almost all the responsibility is on the landlord, because the landlord doesn't want people that they didn't hire touching the building. They want to have full control over who the repair person is, who the contractor is. They don't want someone coming in doing dodgy work. So again, that's why keeping the lease somewhere you know where it is and it's dry and it's safe can solve a lot of problems on the back end.
Folks, we're coming up on an hour.
All right.
So I wonder if we wanted to touch, do you want to touch on the, with holding rent? And then we can open it up and take.
We can do that because this kind of dovetails. So again, we talk about repairs, and a lot of times you have repairs, you may have an ability to reduce your rent. So yeah, let's get to that. Okay, so I can sort of paraphrase what's on the slide before this, but again, if you want to let your landlord know about an issue with repair, don't rely on a call. Maybe some landlords are good and they'll respond to it. Put it in writing. Because if you get hit with a lawsuit in the back end, being able to refer to an email, a text or something is going to be better than, I swear I called them and I have no way of proving it. There is also a back door potentially to getting your rent reduced. This form also comes from the Florida Bar. You can just Google Florida Bar eviction forms. There's about 14 of them. This is one of them. This is the form you can use in theory, and there are some risks I'll explain, to get your rent reduced based upon a violation or something wrong with the property. Again, the big ticket items are these structural components: foundation, roof, walls, exterior windows, doors, windows. So you essentially put the landlord's information in, you specifically describe what's wrong. Personally, if I was filling this out, I take pictures too. I want to make it seem more believable. I think there's another slide here. Okay, so you're going to give yourself some problems if you withhold the rent without sending the notice. Also too, you have to give them 7 days to repair it. The law is trying to be fair here, that yeah, something's broken, but you got to give the landlord a chance to repair it. And there's a little bit of flexibility and discretion. So, especially with the air conditioning, I think is a good example here for, let's say the landlord is responsible for it. You give them the notice, and on like the 5th day, they send someone out there, they try to start doing repairs, but there's some part that they don't have, and they need to get it. It's gonna take 4 more days for the part to come. So now it's gonna take 9 days to repair. You probably can't withhold rent there because the landlord is essentially acting in faith. They are responding to the complaint, they're trying to repair it. The issue is if you give them notice and they just don't do anything. Now you have a much better chance of withholding it. So you prepare that form, you give them 7 days. If they start trying to make repairs, then you probably can't withhold it yet. So the other big thing here is eventually there's a difference between the building being tenantable, you're able to live in it, it's habitable, and it's untenable. It's no longer safe to live in. If it's untenable, you may be able to get out of the lease entirely, and you may get almost all the rent set aside. So if it's still, you can still live in it, it's this bottom point here, then the rent may be reduced in proportion to the total value here. Honestly, this is probably the judge is making the decision. It's not going to necessarily be up to us. It's hard for us to say. The judges see a lot of these. They make the decision on that. So it is very tricky here, and I want everyone to pay close attention here. If you do fill out one of these notices of withholding rent, this almost comes straight from the bar. You should essentially set aside all of the rent as if you were going to pay in full. The bar recommends that you put it in a separate bank account. I understand it may be a little bit impractical for some people to open up another bank account. So I don't know if you need to pull the money out, store it somewhere safe, or just be responsible watching your finances, not overspending it. But in theory, until the courts tell you that it's either completely uninhabitable or untenable, or it's of reduced value, you need to have the whole money set aside just in case and say, you know what, we don't agree, you can still live there, or it's not that big of a deal, because then you will owe all the money due. So set it aside, and it's the same way that you dispute taxes here. So if you had an issue with your tax bill, you want to dispute it, you have to pay the full tax up front. On the back end, you can get a discount, and it's essentially the same idea here. So they say that you really need to, basically until they give a ruling, you need to keep paying the rent as it comes due during the legal proceeding regarding you withholding the rent. Then after the court rules one way or the other, then maybe you'll get some of it back, or the court says, hey, no, you needed to pay in the whole time. Well, now you're good, you've been paying in. So do set the money aside because you don't want to feel like you had a legitimate gripe that the property was in bad condition. Now you spent the money, now the rent's due, now you're getting evicted for a failure to pay, and now you're kind of compounding your problem. So set aside the money, and if it goes in legal proceeding, you need to keep paying it as it comes due. And the court registry, you have to literally go into the courthouse and pay at the courthouse and just put it in there.
Question.
Yeah, I have a question. So in the scenario where, say, you're like, okay, like, look, something's happening with the roof, you know, and the landlord's like, yeah, I see that that's a problem, and you give them a notice, and they're not repairing it, and you reduce the rent, but you don't reduce it fully, so you pay, like, say you pay half the amount, and the landlord accepts it, and then another month goes by, and the landlord accepts another half the rent. Does this thing about the tenant will have to pay all past due kind of into the registry, is that only with that landlord kind of came back and then sued and said? Like,
So
this
the past due in that scenario would be, you paid half, then afterwards, well, the judge says for some reason or that, like, it was fine. Now that money is past due, so that would, it could potentially retroactively refer to what was withheld there. Yeah, that's a tricky one. Now, granted, I would feel personally a little bit stronger if water is coming out of my roof, because that's such a obvious structural component. Like, you're probably going to be okay there. But yeah, in theory, if you're got a problem with the roof, you're paying half. Yeah, I mean, honestly, I would personally keep paying it in. I would almost keep paying it in full, and then make sure I got the court register. So what happens is the judge rules in your favor. You can do, it's called a motion to disperse from the registry, disperse the money, and then the judge says, hey, the house is worth half of its value, return half of the rent paid in to the tenant, and then, you know, you've now gotten your money back, but also too, you're still meeting your obligation to pay the rent. It's very tricky. Honestly, again, the better thing is to let them know and give notice, keep good records, and hopefully the landlord will respond.
Does that keep you from paying the late fee too? Like, if you fill out this form, does that, you know, because you're gonna be late, obviously, because you're withholding, so I'm sure going back to that line, you know, are you entitled to have to pay the late fee because you're withholding rent?
Yeah, it's tough to say. Again, that's kind of where you might be in the advantage of putting it into the court registry, because now the court is essentially holds it in escrow, aka they have custody of the money, so it's not going to the landlord yet. It might very well come back to you. And if you do it that way on time, then you can sort of, and it's really all about preempting it. Is like, it's almost like in good faith, like, we're putting in this neutral party, the court, and I paid it on time, so no late fee potential issue there. The judge is gonna rule on it. Am I being unreasonable withholding my rent, or did I have good reason? The judge like, you're right. It was uninhabitable. You get all the money back. Or it was 50% the value. You get half of what you put in back. But I would still recommend paying it on time into the court registry. You're almost always gonna run into problems when you're not paying rent, especially if you're not paying it on time. So it's tricky, but that would be my advice there, would be just pay it on time, but pay it into the court registry, because then you have proof that, oh, I had the money and I paid it on time. But we'll argue in the back end how much of it they get to keep.
Are there times where you must deposit into the registry of the court versus choosing to?
Yeah, the big one would be if you were in an eviction suit for a failure to pay. So the 3-day period has passed. They've now drafted a complaint saying that you didn't give me the property back, you owed money for these months. Now you have 5 days to respond, and you basically have to either, you know, file an answer with the court. You could ask for a motion to determine rent. No guarantee that they're going to do a hearing on that. And also, like, you're supposed to pay money into the court registry. You can really run into problems with either a clerk or a judge default. If you don't file anything, they just clerk default. You didn't put any money in, you didn't file any written response. You put a written response in, but no money in, they could try to go for essentially like a court default. And they say that, okay, fine, they gave an answer to the court, but there is specific statute language that requires you to pay into the court registry. So yes, that is a scenario. Now, if you're not gonna pay in the court registry, I would hope that you're filing a motion to determine rent and saying that like, I either can't figure out what I owe, or I paid other rent and like this notice is wrong, so I need a hearing, or one of these structural components is broken. I need to have my day in court to explain how the property just isn't worth the full rent. But yeah, that is a scenario where you're required to pay, and you could in theory be inviting an eviction if you don't get it, or you also don't get the hearing more commonly. We go to the next one. Yeah, honestly, this is so huge. If you receive a summons, contact a part of lawyer legal aid right away. Do not wait until the day that the answer is due, because if you just think about practically, maybe you did pay it and that notice is wrong. You're not doing yourself any favors giving yourself half a day to respond. You're not doing yourself any favors if you need to dig up maintenance requests from a year ago, 10 months ago, whenever it was, because you might actually have a real factual or legal defense, but now you've made things harder on yourself. You've prejudiced yourself by waiting for too long. So reach out right away too, because an attorney who deals with this every day might notice a technicality, and this is all about evictions is dotting your I's, crossing your T's. That's probably the number one thing that saves tenants and buys them more time in the eviction suit, is that maybe it's not that you had all the money to pay, but they didn't dot all their I's and they didn't cross all their T's, so they gotta start over. But maybe now you've got a new job, you caught up on your money, you're able to catch up. So just responding quickly, don't get freaked out, take a deep breath, ask for help, go to people that can help you.
Do you have to wait until you received a summons to see a lawyer?
No. Frequently too, there's going to be a little bit of a in-between period where the 3-day notice period has passed, and then the summons is just the fancy court document saying that, hey, you've been sued. Here's the document, the complaint that shows what we're suing you about. You can always find that on your given county's website. So here we're in Pinellas County, Pinellas Clerk of Court. If you know you're probably receiving an eviction suit soon, there's a field. Type in your last name, type in your first name. If you're getting sued, it's going to show up, because you might be able to see the complaint a day or two, or even a little bit longer before you get served the summons. So the clock starts ticking when the summons arrives. Summons arrives, you get 5 business days, and it's kind of like the 3-day notice rule. The 5 days can't end on a legal holiday, and it can't end on the weekend. So there's a couple of extra days possibly if you look at the complaint and you get it to an attorney before you get served the summons, and maybe it falls on a weekend or holiday, and now you, instead of having just regular 5 whole days, you got 7, 9, 10 days. So strategically, yeah, I mean, the earlier you can look at it and get it to someone who deals with this, the better your chances are. Any questions?
Yeah. Well, everyone, thank you, Brooks. I'm going to go a little bit over, but I think you're welcome. You're okay with taking some questions?
For
if folks
sure,
have
for
some more
sure.
Specific questions. And then otherwise, also on evictions, we have some flow charts that you're afterwards you can take a look at that really explain the full process of how it moves through the courts.
Yeah, by all means. I would encourage anyone to, if you want to go there and take a picture, go ahead. There's one that deals with rule violations, irregular termination of tenancy. Hey, I just want you out, no specific